Once the education of their children was complete, a pair of trust beneficiaries tried to terminate the trust and claim the assets. Whether they could do this was the subject of In re estate of Brown. Andrew Brown died in 1977. He settled his estate in a trust. The trust was first to provide for the education of the children of his nephew, Woolson Brown. This use was to continue until the last child's education was finished. At that point, the trustee was to then use the income and principal of the trust for the care, maintenance, and welfare of Woolson and his wife, Rosemary. This was to help them live in the style and manner to which they were accustomed for the rest of their lives. After Woolson and Rosemary died, the trust was to be paid to their living children in equal shares. The trustee duly used the trust proceeds to pay for the education of the children. After this was complete, he began distributing trust income to Woolson and Rosemary, the lifetime beneficiaries. In 1983, Woolson and Rosemary petitioned the probate court to terminate the trust. They argued that this was necessary to accomplish the trust's purpose of maintaining their lifestyle. Their children, as remaindermen, consented to this action. The probate court denied the petition to terminate. Woolson and Rosemary appealed to the Superior Court in Washington, Vermont. The court concluded that the trust's only material purpose was the education of the children. That purpose having been accomplished, continuation of the trust was no longer necessary. It reversed the probate court's decision. The trustee appealed to the Vermont Supreme Court. The trustee argued that the trust couldn't be terminated because it was both a support trust and a spendthrift trust.